actually makes a contract legal? Is it something you can write yourself? Is it something that has to be notarized? Is there some specific phrase that has to be inside of this contract to make it legally binding? Let's talk to a professional IP and entertainment lawyer to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
A conversation came up this week in one of the photographer forums that I'm in, and somebody asked, what makes a contract legal? Is it something you can write yourself? Does it have to be notarized? What's the thing that makes a contract legally binding? Can you break that down for us, Tony?
Yeah, there are a lot of layers to that, but I think it all starts with, first and foremost, kind of I want to say maybe more of like a philosophical, maybe policy approach to contract drafting, which is that there has to be essentially a meeting of the minds. Whenever you enter the bargaining table for, like, let's say, personal service agreement or a contract related to the sale of goods or anything in between, there has to be an understanding on both sides of the table. The person providing the services has their perspective, but the person receiving those services has their perspective. The person selling goods has theirs, and so does the person receiving those goods. So when you enter the bargaining table, there has to be essentially this sense of unison, this combined joint effort that they want to get a deal done. And that usually that unity essentially happens once a negotiation is complete, but meeting of the minds is a core element to contract drafting, contract making. Any law school professor will tell you that. Now, beyond that, a valid contract consists of essentially three parts: offer, acceptance, consideration. The offer is a manifestation to enter into a bargain that is clear, explicit, and definite, and leaves no room for negotiation. Acceptance is basically the assent to carry out the terms set forth in the offer, and then the consideration is when basically the exchange happens that is either a detriment to the promisor or a benefit to the promisee. It's usually one or the other, but the essence of it is you have a deal, or you have an offer rather. I'm going to offer photography services for $2,500. And maybe there is that room for negotiation, but once it's pretty much final, that's where it becomes a non-negotiable term. So let's say it started off at $2,500 and it ends up at $2,000. That's where you pretty much have a firm offer at that point. You accept that $2,000 offer. The acceptance is $2,000 in exchange for photos, for whatever the photographer is going to provide. Now, here's the $64,000 question. What makes then that contract or those terms enforceable? And that's really going to vary depending on who you talk to. And I think that it's always a wise choice, if especially you're in the small business space or you're an entrepreneur or what have you, you're in the business of contract dealing, to talk to an attorney or any legal professional about this. But obviously, if you go down this route, caution. But always go down the route of talking to an attorney to lay out what is the best strategy with contract drafting, because especially if you're in the business of providing services or selling goods, you want to make certain assents, but you also want to have certain carve-out provisions or any boilerplate provisions that are going to protect you as well. So it's important that, since you mentioned photography, if you're a photographer, you may want to lay out a contract term that says, in consideration of $2,000, I'm providing 1 hour of photography services. You don't want to limit it to a number of photos. You want to limit it to the time that you're going to spend taking those photos. You want to make certain representation of warranties. You want to certainly maybe lay out that even though you're providing photographs to the client, you are still the copyright owner of those photos. Or if it's negotiated where the recipient will become the copyright owner, that would be something that would have to be drafted to. You would want an indemnification clause. You would want a choice of law clause. What if there was a breach? Is there an opportunity to cure the breach before it boils over into a full-blown breach of contract claim? All those legal provisions are cemented by way of a contract. And I'm a firm believer, at least in the line of work that I do every single day, and in all my years having reviewed contracts, emails work to some extent, but they're not the best way of contracting. A nice tangible sheet of paper, and I'm not talking about a term sheet, I'm talking about an actual contract that lays out who the parties are, what the consideration is, what are the services, and all those other boilerplate provisions are going to be core and essential to having a good functional document. signatures by both parties, you call it a day. You've got a contract at that point. There are some scenarios where you may need it notarized. Like I know it's I'm almost certain it's done on a across all 50 states, where if, like, let's say you sign a will, there have to be witnesses present there. That's not really a thing I've ever heard of here in the U.S. In any jurisdiction, I've never had to get a document signed by a witness or even notarized in any way. More or less, it all boils down to just having both parties that are the core of the transaction signing that document. So that's my very long roundabout, but in-depth way of kind of laying out the essence of contract drafting.
So when it comes to contracts, people do have to have a meeting of their minds. You have to agree on the terms, and then both parties do need to sign it in order for you to make sure that it is enforceable. There are some outliers with emails and things like that when you're having discussions and oral contracts, but the best way of doing that is getting that written, signed documentation that can then be enforced in a court of law should something happen. If you have questions on contracts, on whatever you're doing inside of your entrepreneurial experience, we would love to get those questions answered for you. Tony's coming back for upcoming episodes, and as always, you can reach out to Tony on his social medias. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor, and you can check out my entertainment law podcast called End Scene. New episodes released every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop your questions down below. Tony's coming back for upcoming episodes, and we want to make sure we're helping you to stay legally protected in the entrepreneurial space. So Tony's coming back for upcoming episodes as we get breaking news in the space and continue to answer questions that we see popping up in forums, in discussions, and in our comment section to make sure that you are making this your most profitable year ever inside of your entrepreneurial experience without having any issues with the legal side of things. And follow along for daily videos helping you navigate the world of TikTok, Instagram, YouTube, live streaming, Lemon 8, and the tools and technology you need to save time and effort creating your social content so that you can get back to running your business and living your best life while still putting your content out there under 5 minutes start to finish every single day so that this can be your most profitable year on social media ever. We'll see you in the upcoming episodes.